Today we're going to discuss about the H1B lottery registration starts today on March 1st of 2022 and the end date is March 18, 2022. We're going to discuss about the dependents green card, especially the attorneys who have filed green card applications in October of 2022. It got rejected, then they accepted, and now they denied the application saying that you filed late. We're going to discuss about that. We're going to discuss about the interfiling from EB3 to EB2, the new 485J supplement and the new California address, how that's working. We're going to also discuss about what's going to happen in the State of the Union address that Biden is going to do in the Congress. Will he discuss about immigration? If so, what are the things that he will expect to discuss? Emily, what's going on with the registration? Is everything going smoothly? You just go in, log in, pay $10, you get registered?
I wouldn't say it's quite that smooth. It is working. I've been able to register several of my clients today, but there are some glitches involved. Right now, for the attorneys, it doesn't ask this question, but the answer comes out saying that we're not licensed or eligible to practice law, which is false. And then it also says that the client who's signing this form electronically doesn't understand English. It automatically answers no to that question, even though it doesn't even ask the question as you're going through the process. So it makes clients a little nervous that there's all these glitches. I'm having difficulty paying the fee for one of my companies right now. So it's working, but we'll see.
Yeah, seems that our H1B guys are not designing these websites. If they would have been smarter and would have designed English as their main language, not something else. Seems to be, I don't know what these guys are programming, that they should turn over the USCIS programming to the H1B guys. They should ease the restrictions in the USCIS to hire the H1B guys. In that way, they won't create any problem because our H1B guys are much smarter. And now, Emily, what about on some of the green cards that you're hearing, you're getting denials of the green cards after the 485 has been filed? Can you explain?
Yeah, so I think a lot of people are aware in October 2020, we had a very different version of the 485 form that was a bit confusing when a dependent derivative is filing along with the main applicant. Some attorneys were completing the form one way, some attorneys were completing the form a different way. And those that were doing it a different way actually got rejected of the 485 when they filed.
Mostly the dependents.
Yeah, for the dependents, because they didn't like how that form was filled out. And you remember, we didn't get these rejections until February of 2021.
And by the time the date backlogged.
Right. So attorneys were resubmitting these applications with an explanation that it was wrongfully rejected. Kept having to do that multiple times because they get rejected, and then finally
in the March of 2021 the USCIS said, oops, we realized a mistake, please file the application back again. Even those rejected applications, they send a letter to them saying that, hey, file your application back. Yes,
and now they're saying they're denying they approve the primary applicant, so now that person has a green card, no longer in non-immigrant status, and their dependent spouse gets denied because they say, when you finally filed and we accepted your application, the priority date was not current, therefore a visa wasn't available to you, and we deny. That puts the spouse in a very difficult situation because now they don't have their non-immigrant status to rely on if they were on H4, for example. Because
the spouse got the H1B approved, H4 is no longer valid, and we cannot file the green card application based on the spouse being a green card holder, and the 485 has been denied. In this situation, so what we are advising people is to first file the motion to reconsider for the 485 denial. At the same time, file a I-130 and 485 application, request for the excuse for being unlawfully present in this country from the time the 485 has been denied, and file the 485 and fight it there. Both ways, not just one way. In that way, if something fails, they have the other thing. Hopefully, so the USCIS is going to rectify it just like the way they did it in March of 2021. They're going to recall these things, reopen these things by themselves. But of course, I would not rely on them saying that they will do. I would file a motion to reconsider and file an I-130 and 485 so that things can be taken care of.
Yeah, and another thing you could do if you were in that situation and you've refiled and your cases are still pending, and now your final action date is current again, you could consider filing again. File another 485 application if your dependent spouse has continued to maintain status. That way, if the first one gets denied, you've already got the second one pending. And those second filings generally have been approved faster.
Emily, any updates on the interfiling? Have you got any receipt notices, any approvals, any intimations? Remember that we made a big deal in January last week of 2022. Yes, we got it. We know how to do the interfiling right now. Finally, we learned how to do the interfiling. Finally, USCIS learned how to do the interfiling, and they started doing the interfiling. They have given a new form. Well, they use the existing form. They have given a new way of filing interfiling. Anything happening on that?
Not one. Not one receipt, not one approval, not any update in the case status showing they're doing something.
So you took all the money and didn't give any result to your clients?
Not on purpose, that's for sure.
Guys, it's definitely, we have not seen anybody getting receipt notices, anybody getting approvals in the people who have used a 485J supplement and sent it to the USCIS address in California. Nothing happened with those. No approvals, no receipt notices, no updates from USCIS, no information from them at this point of time. So when you want to evaluate if you're still maintaining a non-immigrant status, you may want to consider to see if you want to refile the entire 485 application, or if you want to still see if the interfiling is working. When the interfile was being introduced, we have told, please log into our channel. We are going to update it. Now the update is, there is no update, none whatsoever at all from the interfiling. Nothing is going on. Yes, we are taking money to file the interfile, but we haven't seen any result yet. Emily, now the priority date has moved forward for a while, and it is expected to move a little bit further, but it doesn't solve the whole purpose. The whole immigration still, it's going to take maybe 50 to 70 years for the people who are applying for the green card. Maybe they'll be alive, maybe they'll die before they get the green card. Is there any solution for this, Emily?
Well, there are definitely things that President Biden can do. And there are ways that, we're having the State of the Union address tonight. I don't think immigration is going to be the headline hot topic that's discussed because we have other things going on, particularly with the situation in Ukraine. But I do think immigration will be discussed. The question becomes, what is he going to say about it? Is he going to put the ball back in the court of Congress and say, hey, it's your job to fix this? Or is he going to move forward on his own? There are things that he can do. He can make sure that the work authorization, instead of making it only valid for 180 days during the gap period, make it a year. If you're going to take a year to process EADs, he can do that with a stroke of the pen. He can also fix the long processing times of EADs. That's the executive branch. That's his job to do. He can also stop separating applications. They're separating the H1 and H4. They're separating the L1 and L2. Why?
Biometrics for F1 visas.
Yeah.
B2 extension biometrics.
And the forms, the length of the forms. Do you remember back in the day when the G28 was one page, the I-765 was one page?
LCA was one page.
Yeah, and now the I-765 for a simple EAD that takes 5 minutes to approve, it's a 7-page form. The G28, just to allow me to represent a client, is 4 pages. And this interview requirements, biometrics requirements, they just made every single process so much more difficult than necessary. These are all things that Biden can do that does not rely on Congress. We'll see if he also pushes Congress to try to get something passed after November.
I don't think
it's
so.
Not going to happen before November.
I don't think so that this administration should realize that in the Obama time, the Congress did nothing. And they should realize that they're not going to do anything at this point of time too. So they should try to act unilaterally instead of actually doing any action. Instead of waiting for the Congress to do any act, they should try to act by themselves. Emily, let's go to the question and answers. Any luck with the Texas Center 485 process? We do update the processing of the 485 from my desk, actually, but it's actually published by Emily's blog. Well, that's we consider as stealing the things, but that's okay. I let her do it. Right now, Texas Service Center is the worst service center as of now in getting the receipt notices, getting the approvals, getting the EADs, getting the biometrics. It's definitely is worse. But Emily does publish things in the immigrationgirl.com, so you can watch the details in there, how the 485 processing is happening, which service center is approving. Surprisingly though, and this is what is very frustrating to us, is that when we look into the proportion of cases that we filed in October of 2020 as compared to the proportion of the cases that we filed in October of 2021 and afterwards, though the cases that we filed are after October of 1st of 2021, we got more of those cases got approved proportionately than that of the cases that we filed in October of 2020. It's really saddening though. They don't go by last come and first approval. I mean, first come, first approval, sorry. They don't go by first come, first approval. They go by, I don't know, what principles do they have?
I don't think they have any. It is just all across the board. Nothing is making sense with what they're doing. They don't have the resources to properly adjudicate these timely, and they're just playing a shell game, really, just moving officers from one location to another, one type of case to another, leaving other cases to lag so that they focus on a different one. We see that now with this idea that EAD and AP, which have been approved together in the majority of cases for the last 10 years, now they're approving the EAD by itself, supposedly to improve EAD processing time. So what is that going to do to the AP processing time?
Yeah. So people are asking about NBC processing of 485. Is it better? Definitely, it's definitely better. This question comes from Momo Lee. It's definitely way, way better than Texas Service Center. The good part about it is that somewhere in October to November of 2021, we have seen some NBC cases moving to Texas Service Center though, but in the past 1 month or 1.5 months though, we are seeing more of the cases from Texas Service Center moving to National Benefit Center, which is actually good news because NBC is way, way faster than Texas Service Center. Hopefully so that will continue so that things will get adjudicated much faster.
Sarah Bonin says, I filed my PERM PWD, that's the prevailing wage request, with the new employer in September 2021. No updates from DOL so far. What is the processing time these days? Right around 6 months, so it's probably going to be March before, which is March today, so it should be coming soon, but we are seeing 6 months.
Questions with regards to the H4 EAD is expiring in May of 2022. We filed the extension of H4 plus EAD. What is the best solution to expedite it? Well, we don't know of any method that can expedite it much faster, but what we have noticed is that there are ways where you can circumvent the H4 EAD by going to, once your spouse's H1B is approved, you can fly to Mexico, you can stay there for 1 or 2 nights, you can come back and show your spouse's H1B approval. They will grant you the H4 until your spouse's H1B approval. So in your case, most probably your spouse's H1B will be expiring in May of 2025. So you can, if you get that I-94, which we have seen that 95% of the people are getting in that way, because of the new changes in the rules though, even though your EAD has expired, if your I-94 of the H4 has been extended, you can work for a period of 180 days after your EAD expires. So we want you to use this method. There is a video that we posted 3 weeks ago. We want you to watch that and then you can resolve that, because you can try the congressman, not working, ombudsman, not working, EMMA, not working, expedited request, not working. For 98% of them are getting denied. So this is the best way we have discovered. We have tried it on many people, and many people have used it, gone to Mexico, came back, and they got everything resolved very properly. Even if you don't have the passport visa stamped until May of 2022, as long as your I-94 is still valid, you can still go to Mexico and you can come back and you can extend it until 2025.
Zane says, if my final action date is current, do I have to file an I-824 in order to convert my approved I-140 from AOS option to consular option? Yes, if your I-140 petition indicated that you would be filing adjustment of status in the U.S. rather than consular processing, then your company needs to file an I-824 to have USCIS notify the National Visa Center that your I-140 has been approved and now you're consular processing.
My EB2 I-140 has been approved. My EB3 I-140 is still pending, which was filed in October of 2020. Is it a good time to do the interfiling? We do not recommend to do interfiling if your EB3 I-140 has not been approved, because according to us, it's still the underlying EB3 I-140 has not been approved. Since it's not been approved, we do not recommend though. It may be a better strategy for you to have it expedited by filing the premium processing and get the I-140 approved, then do interfiling. The other option is that if you have not used the EAD and advance parole, still maintaining the non-immigrant status, you may just want to refile the entire 485 application, because if that's sometimes is much faster than actually going back and doing the interfiling of the EB3 to EB2.
Sumit has an EB1C AOS that's been current. The I-140 was approved back in September 2021. AOS was filed back in October 2020. He wants to know how much longer it might take to get a decision from USCIS. I would say it could take another 6 months. That's what I've been seeing in my cases. It's a very long processing time for the 485, even though the final action date's been current and the I-140's been approved for some time.
Question from Harry Caps. Is there a restriction on number of visits for a person to make on a B1, B2 visa in a span of 3 months? Harry, if they have a genuine reason to visit into United States, for example, for their business, they have to come a couple of times to meet different people though, that's perfectly okay. What they are looking more is not how many visits that they are making, but each visit, how long they are staying in United States. If each time they are coming in, they are staying less than 1 month, they should be fine. But each time if they are coming in, they are staying for 6 months and then leaving, coming here again, immediately staying here 6 months, that definitely is not a good sign. They may be turned back when they keep staying here for a long period of time. But in a short span of 3 months, they come, stay 15 days, go back, come here for 15 days, go back. We haven't seen any problem for those people.
Trishit says, what happens when the H1B and H4 is pending for an extension while traveling and then gets approved while outside the U.S.? How is the I-94 affected in such a case? Well, assuming you were in the U.S. at the time of filing and then you exit and then the application gets approved, it will be approved with your old I-94 number on it. Then, depending on whether you have the visa stamp or not, you can either go for stamping or use your valid visa to come back in. When you come back in, you'll get a different I-94 number, and you need to check to make sure that you got the new end date on your extension. So as long as you have the new end date on your extension, you've got the new I-94, you're all set.
Srinath Reddy has this question. I've completed 6 years H1B on non-profit organization. Now I want to move to for-profit organization, got an opportunity. What are the things that I should be checking with the lawyer? First thing is that you will have to go through the lottery system even though you have an I-140 approved. I'm assuming that you've never been counted towards the lottery because you work for a non-profit organization. The main thing is that you cannot start working until October 1st though. However, there are some exceptions if you want to still work for this for-profit organization. If, let's say, for example, you are working for University of Texas, and let's say you got a job opportunity from Walgreens, though. Of course, they can file a H1B in the lottery system, and once the lottery system get approved, you can start working with them. After you get selected, you get the H1B approved, you can start working from them October 1st. But there is also an exception, though, that the Walgreens can file something called concurrently filed H1B. That means that you're going to work for University of Texas, but you're going to also work for Walgreens. In that case, though, you do not require to be counted toward the H1B number. It's only when you're solely working for Walgreens, that's when it requires that you need to be counted towards the H1B number. So in this case, if you don't, even if you want to work from, let's say, March 10th, the Walgreens can file a H1B concurrently filing that you're going to work with University of Texas and Walgreens, and you can still work for Walgreens. And a lot of people ask, wow, I've never been counted toward the H1B number. Yeah, we know that. We do this with a lot of these doctors, what they call it as moonlighting. They work for the university and they moonlight for this other organization. That is perfectly allowed, perfectly legal. You should explore that opportunity if you want before October 1st.
The note says my I-94 is expiring March 10th, and my employer filed the extension today in regular processing, has the FedEx number. Will I go out of status if I don't get the receipt number before March 10th? Yes and no. So what happens March 10th is you, assuming your extension is pending, you have what is called a period of authorized stay. You're technically not in H-1B status on March 11th, but you're lawfully present in the country based on your pending extension. In your case, though, you don't have documentation of that pending extension, but when the receipt notice comes in, it should show that the filing date was before March 10th, and then you'll be fine. The risk is, what if there's something that goes wrong with that filing, it gets rejected, and you don't get the rejected petition back until after March 10th. Then you're out of status and unlawfully present at the time you're trying to refile. That can be a big problem. So for that reason, we normally would recommend not waiting until too close to the deadline to file. We recommend filing it at the 6-month mark so that, number one, you can get the receipt on time, but also get the approval even before your I-94 expires. Because if you get something goes wrong after your I-94 expires, like a denial, for example, that can be a big headache. So yes, you should be fine, assuming that that application is actually properly filed before March 10th.
Questions from Nitya and also questions from Nitya 2 times actually. 485, what's going on with the applications filed in the 485J supplement in the California? Nothing, no receipt notices, no approvals, nothing is happening with that. That was being stated before though.
Bhagiraj says, I filed my N400 in April 2020, got a waiver for the biometrics in January 2021, no update since then, almost 2 years. My green card is about to expire. What options do I have? Well, since you filed the N400, you're technically not required to renew your green card. You could just rely on the pending N400. The problem with that is what happens if you want to change jobs and you don't have your citizenship yet and you also don't have the valid green card anymore. That could be a problem unless you have your driver's license and your social security card that you took the notation off from that. So option 1 is let it expire and rely on the N400. Yes, those processing times are really bad. 2 years is completely normal right now. Or you can go ahead and renew the green card just to have it as a backup plan in case you need to travel or in case you end up changing jobs and need to show the renewed green card for your proof of work authorization. Emily,
for the 10-year green card expiry, if it's 10-year expiry, is there a penalty if you don't extend it? If it's expiring, let's say, May of 2022, if I don't, is there a penalty for it?
No, no problem with that.
The only problem is the travel is the main issue there. Mm-hmm. A question from Zain that came in is that his I-140 is approved, it was being filed under the adjustment of status. Now his question is that can he now move it to the national, to have it a consul processing? What do he need to do? One thing I would say is that you have to file something called I-824 application. And that takes ever. I mean, 1.5 to 2 years. Plus, there is about 1.5 to 2 years afterwards, the whole process. So at a minimum of 2 years, at a maximum of 5 years, it will take for your I-140 to be moved to the consul processing and give a green card there. Strategically, if you can come legally into the United States on H1B, L1 or any legal visas that are allowed to though, I would, even though you file an I-824 telling them to move the consul processing, I want you to make a way to come into United States on a non-immigrant visa, which is allowed, and then file the adjustment of status, then go into the consul processing.
Jyoti says that wants to know about the refiled cases that were approved that we put on immigrationgirl.com. Was the EB3485 case transferred and consolidated with the one that's at the NBC prior to approval? No, they were not. Those cases stayed at the Texas Service Center, and just the second filing was approved. The first filing stayed where it was, and it automatically was closed by USCIS without us having to take any action. And then she wanted to know if the primary beneficiary was the same on both of the applications. Yes, it was.
Sweet Dabba has this question. EB3 I-148 approved. Prior date is September 2013. Received EAD and AP, but my spouse EAD is pending. She's on H1B. Is it good to move to EAD right now? Yeah, if you and your spouse have filed and your spouse is maintaining the H1B, there's nothing wrong in you moving to EAD. Your spouse will still continue on the H1B, and if your spouse has an EAD, they can move to EAD, but it's perfectly all right. She will maintain the H1B. You can move to the EAD. Absolutely nothing wrong.
Sarisha received the H4 approval, and her husband's H1B is also approved, but her H4 EAD is still pending, and she wants to know if she's eligible for the auto extension of that EAD. So assuming that you filed the EAD before the current one expires, and you now have the H4 that's valid beyond when your current EAD expires, yes, you have 180 days from the time your current EAD expires. So if you've already been waiting for 6 months, then it doesn't work because it's only for 180 days. But otherwise, yes, you do have that option.
Question that came from V. Lakshmi. Can you or AILA pass the Texas delays issues with the administration? Believe me, we are doing everything to do it. We have written letters. We have also created letters at the bottom of this link so that you can write to the congressman to not waste it. Tim Cook, the CEO of the biggest, largest market capital company in the whole world ever existed. First company to touch the $1 trillion, first company to touch the $2 trillion. Tim Cook, CEO of the company, tweeted about the Texas Service Center delay. Now, who am I? Who am you? Yes, we should still do our efforts. We did it. We also drafted the letter for you there at the bottom to advise USCIS not waste any of the green cards there. It's been given to you, and please write that letter. We have done it. Tim Cook has done it. AILA did it. Everybody does it, but they don't get to understand us.
Anamish asks, can I still stay in the U.S. after my GC EAD expired and the EAD renewal did not get approved within that 180 days? Yes, so what allows you to stay in the U.S. is the pending 485. It has nothing to do with the EAD renewal. The EAD renewal is what allows you to work while you're waiting for your 485 to be approved. So you can stay in the U.S., but you have to stop working after that 180th day until you get the renewed EAD in your hand.
Pritham has this question. H4 extension, first time H4 extension, first time H4 EAD filed concurrently. H4 got approved, EAD is still pending. Can she go out of the country and come back to USA? Most probably he will, Pritham has concern whether or not the EAD will be denied because it's pending. No, EAD will not be denied even if your spouse leaves the country. Absolutely not. The H4 is approved, she or he is safe to go outside the country and to come back in the United States.
Craft Creative has a priority date in 2010, received date October 2021. Everything's pending with Nebraska. No updates after the biometrics. Is there any way to get my petitions transferred to the National Benefits Center? Unfortunately, no. We have no control over that. We can't force USCIS to move a petition from one service center to another. The only thing we can do is file a second 485 if that makes sense to you. And those second 485s are often going to the National Benefits Center when the I-140 is approved.
Yeah, I get these questions a lot of time. Why do you lawyers file in Texas Service Center?
Oh, I wish we had a choice.
Here's the reason why none of the lawyers, I don't know of any lawyers who like to go to Texas Service Center. We don't file it. It's based on your address. Now, That by itself doesn't control though. Please hold on, listen to me until I finish this particular thing though. Based on your address though, previously we were allowed to file in Phoenix, Arizona and Texas though. These are the two addresses. It doesn't mean that they will end up there though. They are called lock boxes. Once they go to lock boxes, they will then send those applications to either of the three service centers for the 485. One is Texas, one is Nebraska, one is National Benefit Center. We don't decide even if it's sent to Texas, it doesn't mean that it will end up in Texas though. For the applications that we filed in October of 2020 though, most of those applications we filed I-140 and 485 together. For the I-140 and I-485 together, the applications will mailed, they can only go to Texas Service Center because of the rules at that point of time of the normal processing. Sorry, not Texas Service Center, but it will go to Texas address though. Now, once it goes to Texas address though, then they can actually go to Nebraska Service Center or Texas Service Center. If we file an I-140 and adjustment of status together, they will not send that application to the National Benefit Center though. They will end up 99% of the time, they will end up in Texas or Nebraska Service Center. When we file a 485 alone though, then we can file in Phoenix or Texas based on address where you are, right? Now they created a new address, especially for the New Jersey people, Chicago address. So when we file in any of these three addresses, even it goes to Texas, Phoenix, or Chicago, most probably if it's filed, I-485 has been filed alone, it most probably will end up in National Benefit Center. Now, it's not 100% guaranteed, but it most probably. But when we file I-140 and 485 together, it most 99% of the time ends up in Texas or in Nebraska. Now, for the recent filings, so what we did is that, especially when we have an option to file the premium processing of the I-140, when we are filing premium processing of I-140 and we are attaching the 485 together, we're telling stop, don't file the 485, let's get this I-140 approved in premium processing. Once it's approved, then we are going to file the 485, then we are giving a greater chance for our client to get to the Nebraska Service Center. Those are some of the tricks and trades that we do though. But in cases where we are filing I-140 using a labor certification that was approved long time ago, because based on that they have already filed an I-140 before, and we are refiling an I-140 based on the PROM application, we cannot file the premium processing initially when we are filing the application. So that will take a long time for us to get the I-140 approved. So we have no option but to file the I-140 and the 485 application in Texas address, and it will most probably eventually end up in Texas or Nebraska. That's the reason, please, it's not our choice to end up in Nebraska, Texas, or National Benefit Center, but it's the choice based on the calculations what I told you right now.
Mackie says, what if my current H1 and my spouse's H4 are already expired, extensions are pending along with the H4 EAD extension? Can my spouse start working after my H1 and her H4 are approved when the EAD is still pending? Yes, but that's not usually what happens. Unfortunately, what happens is they'll approve your H1 only. The H4 and H4 EAD will remain pending, so she still won't have that extended H4 I-94. That's the situation where that automatic visa revalidation may be an option for you to go to Mexico with your already extended H1B and come back to get her an H4 that gets extended through automatic revalidation. Then she could take advantage of the 180-day auto extension based on the already pending EAD.
Sam Navin has this question, any updates on the American Competitive Act in the Senate? We are not even following that right now. We don't think so. It's something that's viable right now that can be. So we're not putting our efforts towards the Senate or towards any of those bills right now. So that's the reason why we want you to write a letter to the administration to not count the family members in United States so that we can avoid all these delays though. Please write the letter because we think so that Congress at this point of time is not going to act. Today is the date for elections in Texas for the primary, so election season already started. It ends all the way into November of until November of this year, so they are not interested right now. That's our take on it. We want your efforts more to focus on the administration, to do some changes to get it. Surabhi Sharma has this question. Hey, the regional centers may be expected to start in March. Will that be a dent in the EB2 applications or EB3 applications? Surabhi, you must be more worried about the amount of green cards this administration is going to use up though. Because what Surabhi is pointing out is that if the EB5 employment-based immigration green cards are not used, they will fall into EB1, and since EB1 is not going to be fully used, they're going to fall into EB2. That's what she is trying to look into. Now that's only a little bit, it's not a big number, maybe 10 to 15,000 numbers that will pop up to EB2. What you should be worried about is that there are 280,000 green cards to be given this year. Historically, this time never was there in the history before. This is the first time that we are having the 280,000 green cards. We want to make sure that this 280,000 green cards will be used up. Forget about, the excess green cards that are going to the EB5 that might be coming up to EB2. If they use up the 280,000, I will be very happy, Surabhi. Even if I'll be very happy. So I want to focus on the 280,000 green cards on that. And if the EB5 starts or doesn't start, we don't have a control over that because it depends on how the Congress and the administration is going to act on it. So we should more focus on getting our entire green cards to be given to us. That's more I will be focused on. And I put a letter down there to write to the congressman so that we can use all these 280,000 green cards that are given to us.
Sarah Vonnen says, can we travel to Canada on a valid I-94 and an expired visa stamp without any issues these days? Yes, automatic visa revalidation works for either Canada or Mexico. You just have to travel for less than 30 days, have a valid I-94. You can use an expired visa stamp and not go for visa stamping while you're there. The reason we mentioned Mexico more than Canada is during COVID times, Canada had some quarantine requirements. They also required you to get the COVID test to get into Canada versus Mexico, which did not. Also, Canada usually requires a visitor visa to be obtained in advance to go to Canada. Mexico often does not. So that's why we mentioned Mexico more, but it does work for both countries.
Srinivas has this question. My priority date became current file 485. Unfortunately, the child got aged. What are the chances for him to get the green card based on the family-based immigration? The waiting time for the family-based immigration for the family-based 2B, that is the category that you will be looking into. 2B, that's the category. It's about 6 to 7 years right now. I would say 7 years right now, waiting time for the person to get the green card. In the interim period though, of course, the child should not get married because then he'll be kicked out of the F2B application. So yeah, if the child has moved into a student visa, as soon as you get the green card, the next day I would file a F2B I-130 application. Even though the child has an option of going to H1B after the F1 visa, let the child go through the H1B, that's fine. I would still file the I-130. It won't give an immediate benefit to the child, but it will give a later on benefit to get the green card, because the waiting period for the employment-based green card, where your child has to swim just like the way you did, may be a long waiting period. The F2B may come much fast forward than that of the employment-based.
Santosh wants to know if the receipt date on the October 2020 AOS will be retained if I refile the I-140 with the 485J. In this situation, the I-140 downgrade was an amendment from EB2 to EB3. So in order to now take advantage of EB2, a new I-140 is required because the amended EB3 application took you out of EB2. But you do have the option of interfiling based on this new pending I-140 by using Supplement J. And in that situation, if you're interfiling, your receipt date does stay the same for all purposes except for possibly using AC-21 to change employers, where USCIS says the 180-day clock starts over when you interfile. And with a pending I-140, we generally wouldn't recommend using AC-21 anyways. So in your case, an interfile based on a pending I-140, the receive date of the 485 stays the same.
Question from the Facebook is, hey, I got my EAD approved, but my advance parole is not approved. What to do about it? This is a big danger, guys. I want everybody whose EAD is approved, I want you to check on the EAD. I'm speaking about the adjustment of status EAD. If your advance parole is approved, on the EAD, it will tell that advance parole is approved. If it does not tell that, that means that you don't have an advance parole. I don't know why they are doing it. This is a recent phenomenon that we have watched it. If the advance parole is not approved, you cannot travel on the EAD. A lot of people ask the question, I got my 2-year EAD, now can I travel? It's not the EAD that allows you to travel and come back into the United States. In the advance parole. Now, if you by any chance are not looking into the EAD and then you travel outside the country thinking that you can come back, you will get stuck there and your advance parole will be denied because you traveled. You may have huge trouble. Our videos are watched by at least 25,000 people, and at least 10,000 of them have EADs or will get EADs. Please watch those EAD approvals. If I can save 5-6 people not getting stuck, not getting into trouble, I'll be so happy. Just check on the EAD if the advance parole is approved or not. Otherwise, don't make any travel plans until your advance parole is approved.
Mohammed says, can a person do 2 jobs while on the H4 EAD? Yes, no problem at all. You can do 10 jobs, 5 jobs, you can start a business. Any lawful job is fine, just nothing related to marijuana, even though in some states marijuana is legal. For immigrants, it is not. Rahul says, my I-140 in EB2 and EB3 just got approved in only 4.5 months at the Nebraska Service Center. Is it normal? I was expecting 8 to 10 months for approval. I wouldn't say it's normal, but it's not unheard of. We do oftentimes see cases approved faster than what is posted as the normal processing time. So you're one of the lucky ones that doesn't have to wait longer, unless you're trying to use that time for Child Status Protection Act for your kids who are aging out. Manjunath says, can I take a second job as a coach, 4 hours a week, paid monthly, while I'm on H1B? Are there legal issues? Potentially, but does that coaching position require at least a bachelor's degree in a specific field of study? If not, then it's not an H1B level job and it's not allowed. You cannot do a concurrent H1B for a position that doesn't qualify for the H1B. So when you're on H1B, you can work multiple jobs, but they all have to be specialty occupation jobs, meaning they require at least a bachelor's degree in a specific field of study. And you have to have concurrent petitions filed for every H1B employer that you're planning to work for. So unclear whether you would be able to do that. Not sure if your coaching position requires a bachelor's degree or not. Even if it requires, would they file the H1B for it? That's another thing too. Vishal has a very interesting question. I am on H4 EAD. I'm applying for H1B. If I picked up in the lottery, will I automatically go to H1B, or can I keep working on H4 EAD? Here is a Vishal that I will tell you a solution. There are 2 ways we can file the H1B. One is a consular processing, one is a change of status. So I strongly recommend you do the change of status. If you do the change of status, you would move to the H1B. You will not be considered to be an H4 starting from October 1st once your H1B is approved. I want you to stay there for a month or so, get the pay stub though, then I can convert you back into H4 with no problem. No money to immigration lawyer. All you need to do is, after 1 month you get a paycheck, you fly to Mexico, have a margarita, no paying lawyer, come back, and you say that you're happily married with this girl, which you are, and then you show the H4 approval, you come in, you're an H4 EAD. You don't have to go through the change of status. If you file a change of status from H1 to H4, it may take 8 months to 12 months or something, even longer period of time. Instead of paying a lot of money to us or to the immigration, pay to the airlines and a margarita there and come back, you'll be in H4. Now, why do I suggest people to go through change of status instead of constant processing? Is that for the H1B change of status from H4 to H1 is that. Here is the main reason though. If you get a H1B approval in the consular processing, technically you are not counted toward the H1B number.
You'll be only counted toward the H1B number when you have the I-94, valid I-94 staying in United States, or you get the H1B stamped in the consulate. Since if you apply the consular processing, you're continuing on the H4, the purpose for which you applied for the lottery, which I know you want to be counted toward the H1B number, because at a later date, if something happens to your wife's job, you can move her into H4 and you can get onto the H1B. That's what you want. I know that. So that's the reason consular processing is a bad idea. You're technically not counted. Later on, 1 year, 2 years down the line, you want to change into H1B, you will, if with a different company, then you will have to go to the lottery. Not advisable. If you get the change of status, work for a month, fly to Cancun, have margarita, come back on H4, then you'll be very good. Now, that's called automatic revalidation, that even though you don't have a passport stamping of H4, you can still go outside the country and come back in. We have made a video about 4 weeks ago. You can watch about that if you want to.
AD says, I filed the I-539 for my parents last year due to COVID, and they left before the decision. Now they're planning to come back. Are they eligible to come back, or do I need to check with USCIS for the status on the previous case? We're seeing right now that some ports of entry are saying that visa stamp, the B1, B2 visa stamp that they probably have for 10 years, is automatically canceled because they filed that extension and then it never got approved. They left before they waited for the decision. It's not happening across the board, but there is a chance when they're coming back in that at the port of entry they could say that nope, your visa's been canceled. So there is some risk there. What we would recommend while we have Dropbox available is first have them apply for new visitor visas through the Dropbox, and once they have that, then they can come back in so that they don't face any issues at the port of entry.
Suraj Sheshatri from YouTube has a question. His H1B transfer with the company is pending, and now he's getting multiple offers with H1B transfer. He's unable to choose which company. I'm assuming that you're working with company A, your transfer from company B is pending, and now you're getting offers from C, D, E, F. If all C, D, E, F files multiple H1B transfers, will it cause any problem? No, absolutely not. Now, what happens if the H1B approves? Is the last action rule, that means that the latest one approved, do you have to join? No. Even if your company B, C, D, E, F, all H1B transfers approved, you can pick and choose and stick with company A. Or you can say, I'm going to pick, not B, I'm going to go with D. You can do that. Absolutely no problem. Absolutely no problem with that.
PP says, my priority date's June 2014 and EB3, which is not current. I responded to a medical RFE back in August last year. No acknowledgement from USCIS even after a service request was open. Is there any reason to be worried, and what options do I have? We do see quite often that the online case status does not always update. So is there a reason to be worried? Potentially, because it could be that it wasn't updated because they didn't receive the response. But most likely it wasn't updated because it's a glitch in their wonderful system, and everything is fine. How do you find out? You could try chatting with the live agent Emma on the USCIS website to see if they can confirm that it's been received. You can try an ombudsman request for case assistance on DHS 7001. You can do that electronically as well. You can try a Freedom of Information Act request to get a copy of your file to see if the medical's in there. So you do have some options to try to figure out, did they actually receive it or not?
Questions are coming with regards to the premium processing of the EAD, guys. OMB has been issuing that they are going to do the EAD premium processing, but we don't know their timelines. They give an estimated timelines, which they don't stick by the timelines 90% of the time. So we have to see when they're going to come. As of now, there is no concrete information, no publication of when, the date of when they are going to start. They have not published yet. They said they're going to possibly do it, but they haven't given us a particular time. Like, for example, May 21st, 2022, will start the premium processing. No, they did not say anything like that.
Joyo has a 485J that was filed with a standalone 485, but the 485J receipt has not been issued yet. The 485 was received January 22nd. is it mandatory to receive the 485J receipt? We usually see a delay in the 485J receipt. Sometimes you don't get the receipt until 1 month before they approve the application. So I would not be concerned that you didn't get a 485J receipt. And it also doesn't seem to be mandatory. I've seen many cases where we submitted a 485J and the green card got approved without ever a receipt being issued.
A question with regards to the stamping. The gentleman is asking a question. His H1B is stamped until 2023 May with company A, but now he has a H1B approval until 2024 with company B. He is not working with company A, he's working with company B. Can he travel outside the country, and does he need to go for visa stamping? No, you don't need to go for visa stamping. If your H1B stamping is valid in your passport with company A, even though you're not working for company A, you can still travel, but when you come back at the CBP port of entry, show them the H1B 797 approval with company B. And make sure you get the I-94 until the H1B of the company B's expiration though, not company A's expiration. This mistake happens. So many times people go out of status and it's very hard to correct that one. But you make sure that the company B's H1B is shown, and once you enter into United States, check online immediately your I-94, make sure you got it correct. If by any chance they still gave you the H1B of I-94 until company A's passport stamping, there are ways to correct it if you observe it within a short time after you come into the United States. If you wait until 2025 and then go online, then guess what? You are going to be, you may have worked as illegally in the United States. You may have a penalty of 10 years bar coming back into the United States. But if, let's say for example, you go and come back and immediately in June of 2022, whoops, my I-94 is only given until 2023, not 2024. There are many ways to correct it, easy ways to correct it, not costly ways to correct it, and will not have any bar if you observe it. So that's the most common thing. We also notice that when the passport is expiring though, sometimes, for example, let's say if you are working with company B, you have a H1B passport stamping until 2025, and your passport is expiring until 2023. When you enter into United States though, we do notice that sometimes they only give the I-94 until 2023. That's when your passport expires. So if you observe that though, there are many ways of correcting it. But if you wait until 2024, you check at that point of time your I-94, you will be in great trouble though. We always advise people, once you enter into the country, take 5 minutes. You guys know how to check I-94 online. I don't have to tell you. Go to Google, check the I-94, put in the passport information, boom, the I-94 comes there. So please check that one. It takes only 5 minutes. The most common mistake that can be avoided is this, the passport expiration. People don't look into the I-94 expire on the same day.
Grishma says, I've sent my first time H4 EAD to USCIS on February 28th, and I'll be traveling to India March 3rd. Will this create a problem? It does not create a problem. You just have to be physically in the US on the day the application is filed. So make sure that it has been received by USCIS before you travel. But travel while it's pending, if it's just an EAD by itself, does not impact the EAD process.
My spouse has approved GC-EAD and H4 EAD. Can she work on H4 EAD instead of GC-EAD? Will it affect the GC process in any way? Absolutely not. Who is looking which EAD your wife is working? No, that's okay. You can always give the H4 EAD to the employer. It will not affect our green card process. Absolutely, it will not affect.
Aruna says, my spouse and son EAD approved, but myself is the primary and my daughter's EAD is pending. Yeah, we're seeing all kinds of crazy stuff right now. They're separating family members. Some are getting it, some are not. I don't think there's anything you can do. You can't argue, well, you approved theirs, so why don't you approve ours? Your options are to do just the normal expedite under the expedite criteria, but nothing related to the fact that your other family members already received it.
We are also noticing an uptick in the RFEs, especially they're asking about birth certificate. Sometimes if you don't have a birth certificate, they're asking more about it. Not much to worry about it, guys. I mean, they're also asking for living together documents, that whether your spouse and you are really married together, lease agreement and all those things. Not much to worry about it though. Actually, when an RFE like this comes in, I say, yes, that's very good. The reason is that now this officer is actively working on your file. I'm more happy to respond to this RFE rather than not getting an RFE and then sitting in the black hole of the Texas Service Center. I would rather want to get an RFE on medical, birth certificate, or living together documents. Those are easy to answer, and that means that most probably your case will be adjudicated faster.
Sancho says, my H1 amendment is approved, but my wife's H4 and EAD is pending. Can we still travel out of the country? Our visa stamps are valid until September. Yes, you can. If you're going to return back before September, you don't need to get new visa stamps. And when you come in together, if your wife shows your H1B extended approval notice, she should get the extended H4 I-94, which then allows her to use the 180-day auto extension of the H4 EAD.
Anything else, Emily?
I think we're about out of time for today. Thank you all for joining us. Make sure you join our daily conference call if you have additional questions that you would like to get answered. Otherwise, be sure to subscribe to our newsletter at rnlawgroup.com or subscribe to immigrationgirl.com.
Thank you very much.